Mr. Lofgren, have you filed an affidavit that you mailed a copy of this motion and notice of hearing to Mr. Lofgren at an address?
Yes, Your Honor.
How do you know she still lives there?
Um, she calls her kids every day at 7. So
Okay, so the when she has parenting time, where the children with her, their children are at that home, is that correct?
yes, the children are at my
Right,
home. Yeah.
right. Ms. Barrow, is that the address that the front court has on file for Miss Wendy Lofgren?
That is not her legal address, Your Honor.
All right. Does she have a confidential address?
She does not.
Okay. What address do your records reflect?
In Milan, Michigan.
Mr. Lofgren, you still live in Milan, correct?
Yes, sir.
Actually, you live. Your wife previously resided. Can you attest to the court that she no longer resides at the address?
Yes, I can attest to that, Your Honor.
Who lives there?
That's her sister's house.
Okay. All right. Obviously, you have her cell number. Can you text her and then tell her that we're waiting for her here in court so she can participate in these discussions?
I have, Your Honor. I've called twice and texted twice.
This morning?
Yes, Your Honor.
Okay. And what's your response?
No response, Your Honor.
Okay. All right. The background of this case, this is a post-judgment matter. The judgment of divorce entered in April 2022 indicated that the marital home at Fort, that's where you currently live, is to be sold, correct?
Yes, Your Honor.
Okay. And the two of you were before this court back in August of 2022, some time ago, and the court entered an order that the home was to be sold to the purchaser you had lined up, Mr. Lofgren, for $30,000, unless Ms. Lofgren provided proof of a purchase agreement that she had with another potential buyer for, I think, a little bit more than 30,000. I think it was like 32,000. Of course, the court's memory stands corrected. She indicated she had a potential buyer for a higher price. Is that correct?
Yes, Your Honor.
And you never received that purchase agreement. She never disclosed the name of that potential buyer for a higher price.
No, Your Honor.
Okay, so you're asking the court that allows you to sell since she's not cooperating. Is that correct?
Correct, Your Honor.
And that property is entitled in both your names?
No, Your Honor. It's only in her name.
Oh, I see. All right. Well, why did you wait so long, Mr. Lofgren?
I've been trying to work it out with her, going back and forth, and I just haven't been able to get anywhere with her. She doesn't have any interest in selling the home. She doesn't have any interest in what happens to it. She's washed her hands of everything. She doesn't care. She hasn't even came and visited her kids in a year.
Well, obviously, she's entitled to half the net proceeds. Is there a mortgage on the property?
No.
So it's free and clear?
Yes, Your Honor.
I mean, wouldn't she want some money in her pocket?
I guess not, Your Honor.
Okay. And, all right. All right. So you talked with Ms. Brower, suggested this morning that your motion transferability be adjourned to March 6th at 8:30 for service upon the defendant. Ms. Brower, so would your office then mail a copy of this motion hearing to Ms. Baker at the address she has been filed in front of the court, where the sister apparently resides?
Yes, we can mail a copy of the motion.
Okay. The house will be closed by March 1st.
I'm sorry?
The house will be foreclosed on by March 1st.
You said there was no mortgage on the property, Mr. Lofgren.
It's back taxes, Your Honor.
Oh, back taxes. Has Ms. Lofgren confirmed to you that she's received your motion?
Yes, Your Honor.
Okay, when did you last speak with her?
Last week.
Okay. In times of the essence, closing is not going to occur overnight, Mr. Lofgren. You need to, whoever can buy the property, have them pay the 1 year taxes to get it off the tax list, so it doesn't go into, it's not sold at tax sale, so you can properly close this matter.
I'm not sure if they'd be willing to do that, Your Honor. It's it's a property rehabber. They're going to rehabilitate the property.
You got to have so you want to be able to sign the deed. You need orders to that effect, Mr. Lofton. You wait till the last hour, the last minute, and there needs to be legal documents in place that gives you the authority to sign a quitclaim deed.
Okay.
Mr. Brower, it appears, based on the statements of Mr. Lofgren, that Mrs. Lofgren is aware of today's date and time. She will not appear, will not respond, that she does not live at the address, the address on file in front of the court. Mr. Lofgren, the notice motion that you mailed to Ms. Lofgren was returned as being undeliverable?
No, Your Honor.
Okay, so she in fact has told you that she's received it. She doesn't really care what you want to do with it. Is that correct?
Yes, Your Honor.
This is a very unusual relief, and you're asking at the last minute, Mr. Lofgren. All the court will consider doing is appointing an attorney as a receiver. And that attorney then would have the authority to close this transaction and make sure that the net proceeds are divided equally. After the taxes are paid, they're being expensed to the receiver. Are you familiar with Attorney Dominic Camden, who's an attorney in Milan?
No, Your Honor.
Well, Milan's a pretty small community. I think he's perhaps the only attorney in the city. Right, what the court's wanted to do this morning, since time's of the essence and you got to close this matter, the court did reach out to Attorney Dominic Camden yesterday in anticipation of this matter. Of course, not comfortable giving you full authority to do whatever you want with the real estate. You've got to comply with the judgment of divorce. So the court would be willing to enter an order appointing Attorney Dominic Camden as receiver to facilitate the closing of this transaction. And Mr. Hamden, of course, his rate would be $225 an hour. So when it's closed, he would be paid, the tax would be paid, he'd be paid, and then whatever's left over would be divided between you and Wendy. Do you understand that?
How much did you say it was, Your Honor?
His fee is $225 an hour.
So it's going
to, you're going to look probably, I'm sure, $2,000 to $3,000 in expenses, Mr. Lofgren.
Okay.
And do you have any objection to Mr. Attorney Dominic Camden acting as a receiver that would have the authority to sign closing documents in a deed?
No.
Okay. Do you have a copy of this purchase agreement?
Yes.
Okay. You need to take a copy of the purchase agreement and a copy of this order to Attorney Camden, like today, so that he can close this matter. You need to give him a copy of those past tax bills and tell him that time's of the essence.
Okay.
Ms. Brown, if you can revise the recommendation. Again, I have times of the essence in this matter. I'm sure you can provide Attorney Hamden with a copy of Wendy or with Wendy's phone number and address, correct?
Correct.
Okay, I'm sure, of course, confident Attorney Hamden will reach out to her. So what the court will do is enter an order today. The court will appoint Attorney Dominic Hamden as a receiver to facilitate the sale and to distribute the net proceeds to the parties equally. Is that a correct judgment of divorce, provided the net proceeds be divided equally, Mr. Lofgren?
Yes, Your Honor.
Okay, you're ready to vacate then, correct?
Yes, Your Honor.
You can. What's the purchase agreement say that you'll vacate on the date of closing?
I think we have till April 1st, Your Honor.
Well, you're gonna lose the house if you wait till April 1st. You got to close it next week, right?
Yes, Your Honor.
Okay, and this buyer, does he live in Milan?
No, Your Honor.
Where does he live?
I think it's Farmington Hills.
Have you been in contact with that buyer? Is the buyer still willing to close on this transaction?
Yes, Your Honor.
All right. Okay, so you need to find out where Mr. Hamden's office is and make an appointment with him like today. You're going to call and make an appointment today to meet with him in the next few days. Provide him with a copy of your purchase agreement, also information, and a copy of the order.
Okay.
Do you have an email address?
No, I do not.
Okay, we'll come down in front of the court today and pick up a copy of his order. Otherwise, it's going to take, you won't get it in the mail until next week.
Okay.
I mean, if you want to move on, if you want to say this purchase agreement, you need to come down in front of the court today, get a copy of this order. You need to take that and all the documents. So before you come down here, call Mr. Hamden's office and make an appointment to get him to see him later this week or first of next week, and bring him a copy of all the paperwork, including a copy of your judgment of divorce, the purchase agreement, and a copy of this order.
Okay.
And Miss Barth, you put in there that Attorney Hamden will be paid the $2.25 per hour as receiver, and he'll have the authority to sign all necessary closing documents and transfer documents and disperse the proceeds to pay off the taxes, his fees, and then the net difference between the parties equally. All right, so Mr. Lofgren, do you have any questions?
No, Your Honor.
All right, so come down to the courthouse today in front of the court and ask for a copy of this order, and get in and see Mr. Hamden so you can move on this matter.
Yes, Your Honor.
Ms. Barr, do you have anything else?
Not at this time, Your Honor.
Okay. And obviously, you can find the phone number for Mr. Hamden, Mr. Lofgren, Google it or look in the local phone book. He used to be the mayor in Milan.
Yeah, I've got it.
Milan's not that big. Okay. So make appointment with his office, let him know he's been appointed receiver to sell his real estate, and time is of the essence. And get all the documents together, so bring it in. Get down to the courthouse today to get a copy of this order.
Yes, Your Honor.
Okay. Do you have any other questions?
No, Your Honor.
Okay. All right. Good luck, sir.
Thank you, Your Honor.
Welcome. The parents are present as well as their attorneys. For the record, James Braunlich is present, representing the plaintiff's father, Randy Long Sr. Mr. Long is present. In addition, Attorney Corey Shimmick is present, representing defendant mother, Cora Flashins. Mr. Relations is also present. The court did have a brief conversation with the attorneys this morning, advising that the court did interview Randy Jr. yesterday. Randy, your son, assured me that he would go to school today. He had a plan in place. He indicated he was going to talk with Mr. Mena and Mr. Carter, I believe, and that they would assist him in putting together a plan to catch up with his assignments over the holiday. The court's informed he did not go to school today. Ms. Flations drove him to school as the court suggested and directed, but he could not. He entered the school. Mr. Schmidt, what happened this morning?
According to the email I received from the principal, the minor child basically said, "I'm not effing staying here or going to school." And my client tried to get him to stay. He pursued to argue with her and ended up having to leave because he was being disruptive to the school and other students. It has came to our attention, Your Honor, that there is a Zoom meeting scheduled with the prosecutor's office for December 22nd for the parents to meet with the prosecutor's office for a truancy charges possible against the minor child.
Against the minor child, against the parents.
We believe.
And I did not get to clarify. It's coming from the juvenile prosecutor, so I presume it's the juvenile prosecutor checking in with the parents to see whether or not they wish to proceed and or come up with a plan to get it taken care of. The letter came from Ms. Newland, who is the juvenile prosecutor. The Zoom address is to Ms. Allie Bork, who's the victim's impact person. That meeting is scheduled for the 22nd at 3:45.
However, the school did ask Ms. Flashins this morning if she wanted to basically pursue charges in the juvenile court against the minor child for truancy. And so with that information, we have incorporated part of that into our agreement that we reached this morning, Your Honor.
Correct.
What can the probate court or prosecutor do with respect to minor?
Well, it was anticipated that they could charge him as a juvenile, he put on probation. It gives Ms. Flashins, who's been responsible for most of schooling lately, another tool, hopefully, to push Randy Jr. to attend school.
Should he be charged with delinquency? Is that
well, it would be truancy, but yes.
Okay, I thought the truancy charge went against the parents.
That's what I thought. I reviewed the statute last week, and I believe under the statute, a minor can be charged for truancy.
Okay.
Yeah.
Obviously, it's a significant concern to this court, and I am very disappointed because Randy Jr. Seems to have a plan. So I'm very disappointed and surprised that he would not follow through with that. In any event, the parties have conferred at length with Ms. Barr in front of the court this morning. Ms. Barr has provided the court with a written recommendation. I think we need to address as a review hearing, and perhaps sometime in February. So this is the recommendation. Are the parties in agreement with this, or do we need to proceed with this hearing this morning?
I believe that this is a consent, Your Honor.
Okay.
Yeah, I don't think anybody's in love with it, but I think they agree to it.
Well, we're all here, and that's primary concern is Randy Jr. I don't know what's happened. Things were good with Dad for years, and all of a sudden, I think back in July, there was an incident between Dad and son, and it's just unraveled since then. So both parents need to work to get Randy back on track. 6th grade, it's critical time, and schooling is very, very critically important. Anyway, Mr. Barr provided the court with a recommendation that father should have parenting time on Wednesdays from 5 to 8 p.m. to take the child to dinner. And I will tell you, Randy loves both parents. He insisted I want to spend Christmas with both. And he talked about how much he enjoys it, activity with his dad, that is skating.
Yeah, skating, fishing.
So I can assure you, he loves both of you, and I assured him that we wouldn't be having here if both parents didn't love him as well. Trying to find out what's best for him. But anyway, Dad would have parenting time on Wednesdays from 5 to 8 to take the child to dinner. Maybe Randy's got a favorite restaurant, I don't know. In addition, father should have parenting time on Sundays. On Saturdays, 12 to 7 to take the child to an activity of his choice. He suggested there's a skating rink in either Sumter or Belleville. He said that's something we both enjoy. In addition, father should have Christmas Day from 12 p.m. to 8. All other times would be with mom. The party shall exchange at the sheriff's substation on Netter Road. So Mr. Long appear there. We can't tie up Randy and force him to get out of the vehicle, but show up there.
I do that.
Because, well, he was suggesting sometimes we didn't show up. So show up there. I'm just suggesting that will let him know that you want to spend time with him.
Right.
And mom, drive him there. If he says he doesn't want to see Dad, you drive him there. And the courts require you be there, remain there for at least 15 minutes. And if he won't get out of the vehicle, I don't know what else you can do. I mean, the police can't do anything. But encourage it. I mean, he needs to have a relationship with his dad, just like he needs to have a relationship with his mom. So both you need to appear there, even if Randy Jr. just tell him it could be getting you in trouble if he won't get in the car to drive to that substation. The dads can take him to dinner. Further, it's recommended that Randy shall undergo a psychological evaluation. Price shall split any out-of-pocket cost 50-50. Perhaps your attorneys can assist you in finding a appropriate person, or maybe Ms. Rebels can recommend someone and make sure it's covered by your insurance. Ms. Rebels may be a place to start. Price shall split any out-of-pocket cost 50-50. Further recommended that Randy, your son, shall participate in counseling once a week with Ms. Rebels unless the counselor recommends otherwise. And Dad will contact Ms. Rebels today for his intake and to see if he's got a plan with her to see what she recommends to rehabilitate that relationship. It's further recommended that Randy Jr. misses one day of school and excused, but should notify the school to proceed with charges. Again, this is juvenile delinquency charges against the child. Is that correct? I was not aware that could be done, but if so, that's good. Maybe it'll catch his attention. So what do we do in the meantime? Is Ms. Fleischer going to drive him to school every day?
Yes, Your Honor.
Okay. There's a suggestion he's got some anxiety problems. Is he taking any medication for that right now? Okay. And obviously, you should let Ms. Rebels know that he's not attending school. I don't know what his issues are. He seemed to have a plan yesterday, so I'm quite really surprised that things have changed so quickly. Neither party should make any disparaging remarks about the other parent. I mean, it's your child. Obviously, the last thing you want to do is make a negative comment to your son about the other parent. And the two of you should not discuss this case with the child other than, he's going to see his dad. He's going to go to school. Discussion about that. And then finally, child support paid by Cora, mother, shall be abated as of December 1st, 2023. That's the written recommendation of Mr. Brower. Mr. Shimmick, is this recommendation agreeable with your client on a temporary basis?
It is, yes, Your Honor.
Right, Mr. Barlow, is this recommendation agreeable with your client on a temporary basis?
On a temporary basis, correct?
Okay, so we will still hold out there. Mom's motion to modify custody parenting time, but the court appreciates the involvement of parents and counsel to come up with a temporary plan, see whether this might assist everyone. The court doesn't have all the answers. The court needs the two of you as parents to help the court figure out what's best for Randy. What do you suggest for review date? Sometime in mid-February, late February?
I would suggest mid.
Okay, I just need to like 9 o'clock. What's everyone's work schedule? Mr. Long, what's
my work seasonal and I do long hair and snow removal. So
okay?
Anybody's guess.
9 o'clock.
9 a.m. would work.
Okay. So February 15th, 9 a.m. Just to review all these issues.
Right.
We need to reschedule a hearing. The custody and parenting time, we can do that.
That hearing will be over Zoom, correct, Your Honor?
Yes, yeah. The review will be February 15th at 9 o'clock via Zoom. So the parties can participate via Zoom. Keep the court Zoom ID number and the Ms. Brower, are you able to hear the court?
Yes, I can, Your Honor.
Okay, can you insert it in your recommendation that the party shall appear via Zoom for a review on all outstanding issues February 15th, 2024, 9 a.m.?
Yes, Your Honor.
And thank you, Ms. Brower, for your assistance this morning at short notice. Mr. Bartlett or Mr. Shimmick, do you want to voir dire your respective clients? Do you want them sworn this morning so you can voir dire them regarding this recommendation?
I feel I've already had a direct answer from it. Thank you.
Yeah, I don't believe that's necessary.
All right, Mr. Long, Mr. Fleishman, do you have any questions?
No, Your Honor.
All right, the court will adopt the recommendation. Court appreciates the efforts of everyone. The copies will be mailed out to counsel. Mr. Barley and Mr. Shimmick. So again, you're going to drive Randy to school in the morning and try to get him out of the car?
I have one.
Okay. That's all I can do. And if he refuses, again, when's the next appointment with Mr. Revels?
Currently December 20th.
Okay. Okay, it's
At
next
9
Wednesday.
a.m. We cannot get his appointments moved till afternoon time until after the first.
And maybe there's got to be some consequences. You know, for example, get off his no devices, no gaming. I mean, I don't want you to use corporal punishment. You can't physically discipline him, but it's certainly appropriate. I know there was an issue with Dad before. You got to enforce that too. He's not. He's a juvenile. He's a minor. He can't be driving the bus here.
I agree 100%.
And tell him, I mean, he could end up in the youth center. He can go to school at the youth center.
I was
wants
excited
it.
when we walked out of your room yesterday. I don't know what he did. He said he was going to school. And then when I got him up and ready for school this morning, a mile from the school, it just all started over again. And I even said, you promised the judge that you would go to school. You're straight up lying here.
Yeah. So I think there needs to be consequences. If in fact he's not going to school, you ban him from any devices. Again, what you bought him a cell phone, correct?
Yes.
Okay, take it away from him. Do we need to put that in this order?
No, it's
okay.
Fine. Phone Wi-Fi's gone.
Well, let's Ms. Brower, can we put in this order that if the minor child refused to attend school, the mother will the mother shall impose the consequences, including but not limited to taking away his phone. He doesn't need a phone. I mean, I don't know if he's got. Does he have Wi-Fi in his phone?
He has actual service on his phone, so that way when he was with his dad, he could call me, or when he's with me, he could call his father. But I agree with Dad; it's getting a little bit out of control.
He doesn't need these gaming things, and I mean, there's got to be at that age. That's perhaps the most appropriate discipline. Mr. Long?
That's what got all this started, was I took his PlayStation from him. That's what got all this started.
So who's got the PlayStation right now?
Dad's got PlayStation.
Okay, so you don't have PlayStation in your home?
He has access to it, but after today, no.
Okay, that's what you got to do. You take. Do we need to put that in this order?
No, no. I mean, you could if you'd like to, that would be fine.
I'll put it in there. It's order because I think the court is very strong. Ms. Brower, are you still there?
Yes, Your Honor.
Can you put a sentence in here that if the child does not attend school, mother shall remove all electronic devices from the child? No gaming stations or phones. Other than if he needs a phone, talk to his dad, you can give him the phone. But he doesn't need to be on a gaming station or a phone all day playing games. He needs to be at school. So we'd put this in this order that mother shall impose appropriate discipline, primarily taking away all, I'm not sure the proper term, gaming devices from the child. The child is not at school. Electronic devices. Right. Anything further?
No, sir.
Court appreciates everyone's efforts. Good luck, and hopefully back in school.
Thank you.
He seemed to have a plan. He said, Mr. Mena, and now you would know Mr. Mena's, that they were going to help him reach out to his teachers, put together a plan for the holidays to catch up. Right.
Your Honor, a quick question. Would I guess this is for Mr. Bartlett too. Would the court mind if I speak with the minor child this morning to tell him what these consequences are?
I oppose. I oppose. Maybe he needs to hear it from someone else.
Okay. All right. Thank you.
The record this matter is before the court for the purpose of reviewing any outstanding issues. And this hearing is being conducted via Zoom. Present is Attorney James Bartlett, representing the plaintiff's father, Randy Long Sr. Mr. Long is present with Mr. Bartlett. Is Cora Flashings present on audio?
I am, Your Honor.
Good morning, ma'am.
Good morning, sir.
The two of you have conferred this morning with Mr. Pat from the front of the court, who has provided the court with the following recommendation. It appears to modify parenting time indicates mother's parenting time shall be every other weekend, Fridays at 3 o'clock until Sunday at 3 o'clock. Will mom be picking up from school, or the parties will meet and exchange?
They're still meeting at the substation, what they've always done. Was what
anticipated. All right. So Randy gets the child gets out of school about 2:30, 2:45.
If I may, he's online schooling. That was why the substation 3 o'clock. That may change if he gets re-enrolled. If that occurs, then she can pick him up from school.
Okay. Again, so the recommendation is mother shall have parenting time every other weekend, Friday at 3 till Sunday at 3. That presumably will start this weekend. In addition, mother would have such parenting time at such other times as parties may agree. Obviously, it's important that the child have a relationship with both parents, and both parents need to encourage that. The parties agree that the minor child, Randy Jr., will attend school in person at Jefferson Public Schools. So who will initiate that contact with the schools to see whether they will agree to that?
Mr. Long is carrying the bucket on that issue.
Okay. Do they anticipate promise, Mr. Bartlett? Will the schools generally permit that if a parent requests it?
We don't anticipate a problem. Mr. Long's already spoken with them, but granted, paperwork and final approval need to be acquired. But at the moment, it looks like smooth sailing.
The court recalls there was an incident where the child was disruptive at school. So hopefully that issue has been resolved, and the school will allow Randy to return. I don't know if he was placed on any suspension at all, but he is taking prescribed medication, correct? Anti-anxiety medication, if court recalls.
No, sir, he's no longer taking it.
Okay, all right. So it's further recommended that Randy Jr. shall continue his individual counseling. The parties agree to follow all requests of the counselor and attend counseling when requested. Finally, the issue of child support shall be referred to the front of the court for a formal investigation and recommendation, with each party having 21 days in which to object to any recommendation. That is the recommendation. Mr. Barlow, is this recommendation agreeable with your client, Mr. Long, this morning?
Yes, sir.
Ms. Flations, do you understand the recommendation?
I do, Your Honor.
Do you have any objection to the court adopting this recommendation?
No, Your Honor.
Okay. Obviously, if there's issues, someone can always petition the court. We can review this again. I'm pleased to hear that you both agreed that Randy should go back to in-person school. I think that's good for a person this age. And obviously, counseling is critical. You need to continue that counseling for Randy. And again, in terms of discipline, I think removal of the child from electronic devices is a superb form of discipline. I mean, the young people nowadays are too addicted to these electronic devices. The last order entered back in December, Mr. Barley, indicated that Randy Jr. shall undergo a psychological evaluation. Was that ever done?
No.
Yes, sir.
Oh,
It was
apologies.
done. It was done, Your Honor. I took him through this, one of the doctors. I'm sorry, I'm upset, and I can't remember his name right at this Memum, Dr. Memum. And I was told not to listen to what he had to say to take him to CMH, so we started all back over at CMH.
That explains why I didn't receive a psychological report.
So Dr. Memon did not conduct the evaluation. He just simply referred Randy, your son, to community mental health. Correct?
No, he did. He did do the psychological evaluation, and he wanted me to go get a bunch of stuff done for him. And I was told by one of the CPS workers and by one of the workers over at CMH not to go through with it, just to transfer him over to CMH, in which I did.
Okay, so again, did Dr. Memon complete the evaluation, or he did not?
He did, but he wanted blood work, and he wanted all like some brain scans and things like that done. And I had a few different people state that I should not go through Dr. Memon because I had some feelings about him with my other child, to take him to CMH, in which I did.
Okay, so we have no written psychological evaluation, correct?
Not yet, because it wasn't fully completed because of the way the feelings with the doctor. I didn't want to have mixed feelings taking him to this doctor, considering this doctor had some mistakes before, and everybody makes mistakes. But at the same time, I was told to take him to CMH instead.
Understood. So right now he's in counseling with community mental health. Is that correct?
CMH with Rob. Yes, sir.
Okay, so you do not intend to put Randy through these tests, blood work, and brain scans, correct? You do not intend to complete the evaluation. Is that the court's understanding?
Not with Dr. Memon. We were going to complete it with CMH.
Oh, okay. Do you know the name of the doctor at CMH that your son is currently counseling with?
He is seeing Rob. His name is Rob.
Is he a doctor?
No, he's a counselor. We're still setting up we had one appointment, and the first appointment got messed up, and we had to leave, and so I had to reschedule it. And this will be his third appointment, well, his second successful appointment, and we're supposed to speak with him about it. So we're still in the process of trying to get it all going still.
And you're sharing all that information with Mr. Long, correct, with Dad?
I haven't shared anything with him about Dr. Memon. And moving forward with Rob, I have.
Okay, it's critical. You need to share the information. The two of you need to work together.
And we are, sir.
Child. So if it's just texting, or I don't know if you're using app close, but you need to communicate all that information to Dad so he knows what's going on. And obviously, Dad needs to make sure that if he gets your son to all these appointments. And also that he knows, he needs to know the names of the counselor so he can reach out to them. So you don't know this counselor's last name?
I have it on my phone and in my paperwork, but I don't know his last name at this moment, no, sir. But it is in paperwork, and I'm going to meet up at CMH today and speak with Dad and give him all the information that he needs that I have. Oh,
so the two of you are scheduled to meet at CMH today?
Yes, at noon.
Good. All right. That's just critical. You need to share information. It's very critical. The two of you have joint legal custody. You need to share that information. And that will benefit your son. All right.
I just want respect for my son, and my son listens to his dad and does what his dad, he has a hard time listening to me. I don't know. Dad says I'm a pushover, and I believe Dad's right. I think he needs a more stricter environment right now until he gets past what he's going through. And I'm willing to work with Dad.
Okay. Well, that's wonderful. You work together. And obviously, Dad needs to also inform your son that he needs to listen to his mother as well. All right, so communication is really the key. If you want to improve life for your son, Randall Jr., you need to communicate for his best interest, and both you need to let the other know what's going on. If there's incidents with Randy, Dad, you need to let Mom know that. If he's not going to school, for example, he's got to go to school. He does. All right, Ms. Fleishman, do you have any questions for the court?
No, Your Honor.
All right, you're asking the court to adopt this recommendation. Is that correct?
Yes, sir.
Okay, Mr. Bartlett, anything further from Mr. Long Sr.?
No, sir.
Very well. Do you want to voir dire Mr. Long? Is it necessary? He's obviously participating in discussions with Mr. Pratt this morning.
Just for safety's sake, I guess. Mr. Long, you've heard the agreement placed on record, correct?
Yes, sir.
You're asking the court to adopt it, correct?
Yes, sir.
All right, and I know it's been a long journey, but at this point, you believe this agreement we've reached this morning is, in fact, in your son's best interest, correct?
Yes, sir.
You satisfied with my services?
Yes, sir.
No further questions.
All right. All right. The court will adopt the recommendation. The court believes any agreement between the parents is in the best interest of the minor child. They know what's best, so the court will adopt the recommendation, enter this order, copy mailed out to Mr. Bartlett as well to Ms. Fleishings.
So visitations start this weekend?
Correct. And obviously, any prior orders, provisions of any prior orders that are not inconsistent with this order will continue to full force and effect. So again, if Randy Jr. refuses to attend school, remove all electronic devices. Follow up with counseling, and two, you need to share the information regarding the counselor, the dates of appointments, and so forth. If there's any medication prescribed, Randy, you need to notify the other parents immediately. If there's any incidents at school, Randy's being disruptive, you need to notify the other party. Now we're following you, Mr. Long. All right, thank you, Mr. Bartlett. That will conclude this matter.
Yes,
everyone
sir.
can zoom out and have a good rest of the day.
Jenkins versus Gregory Adair Jr.
For the record, this matter is before the court to review parenting time. This hearing is being conducted via Zoom. The present is Attorney Jason Kazmarek, representing the plaintiff mother, Lauren Jenkins. Ms. Jenkins is present with Mr. Kazmarek. In addition, Attorney William Godfrey is present, representing defendant father Gregory Adair Jr. Mr. Adair is present with Mr. Godfrey. Also present this morning is the guardian ad litem, Leah Werka. When we were last in court November 29th, the court did order that the minor child be interviewed by the front of the court. The court has received and reviewed that report, authored by Catherine Scott. I believe that was sent just to the court. Obviously, Mr. Pratt, you have access to that report as well, correct?
Your Honor, I did, and I spoke with Ms. Ricker regarding the recommendation, and you have my recommendation based off conversations with Ms. Ricker as well as both attorneys.
Thank you. Well, the court has received the following recommendation, and the recommendation is that the current parenting time order remain in effect pending a review hearing. And that the current parenting time, I believe, is week on, week off. It's further recommended that there should be no disparaging remarks made by either party or third parties or their agents in the presence of the child. That's a given, but we'll reiterate that. Further, that all appointments for the child should be placed in the app closed calendar when the appointments are made. Neither party shall discuss this case or these proceedings with the minor child. Further, that father and the minor child shall engage in counseling and follow all recommendations of the counselor. And further, that the parties go back to court to review a parenting time and any other issues on May 8th, 2024 at 8:30 a.m. That is a recommendation. Mr. Kazmarek, this recommendation be with your client this morning.
She's not happy with it. I know we referred to Ms. Scott for input, and I'm not sure what Leah's position is going to be at this point. She thinks that Colton is being mentally, physically harmed and would like some parenting time to be reduced from Mr. Adair until some counseling can be repair the situation. I think she thinks his mental health is very important, and she thinks that may help on a short-term basis to let that happen, let the counseling happen, and come back and review to see if that relationship is getting better. That's what she would like.
Okay. Mr. Godfrey, is dad? Is dad already identified a counselor? Is he currently involved in counseling?
Judge, my client has always been in counseling, but the child's counselor, there was a break of from November 29th till sometime in January when the child went back to counseling because there was no insurance and the counselor moved facilities. But my client, even though he has contacted the counselor 5 to 6 times with no response, mother never notified him of any of the counseling sessions, contrary to joint legal custody, never notified him of emergency procedure going to an ER room, never notified him of dental appointments, all of which the court said to do at the last time. And we've got a violation of the court saying no disparaging remarks when mother texts Colton and says, I want to talk to you this morning. Make sure you, in bold print, record any conversation your dad has with you, okay? If he wants to talk to you, make sure you record it with 5 exclamation points after that. In response, Colton says, I will. That is not the only time mom says to record them. On another occasion, she says, did you record anything your dad has said? That's mom. Colton, he didn't say anything. Really? Nothing? Mom.
Your Honor, I have to object to these. I think it's not been shared with myself, and they're coming in. They're it's hearsay at this point.
Does Miss Jenkins deny such text messages to the child?
She had. I honestly it never really came up. I think we never. But at the same time, Mr. Adair, the phone was taken by Mr. Adair yelling at the child because the child expressed.
Mr. Kazmarek, you're breaking up. Maybe you need to talk directly to the device. It may move your head. It's breaking up. So I'm only capturing half what you're saying, please.
Yes. So, I mean, as far as disparaging remarks, these are largely been from the father's side. The counselor had expressed to Colton to tell his dad how he feels. So he expressed that in a text because the child basically said that he can't do that in person. He feels intimidated, and so he sent him a text. So it created an argument. Dad yelling at the child about this, taking his phone, and again that made him miss a virtual appointment. I understand that my client did not tell Mr. Adair about that appointment. That was in the counselor texts Colton directly about those appointments, and he does those from school. He stays after school and does those virtual appointments from school. We did talk about that. She's going to start putting those in the Apple's calendar. We did a test message today to make sure those are shared appropriately, and she will be sharing those through AppClose, any appointments the child has. So I think that'll be addressed, and I know it is a concern, and hopefully it's addressed after today.
All right. So again, is Colton currently in counseling?
He is with Catholic Charities. Oh, I'm sorry, that's not right. Mia Murphy. We're at Catholic Charities.
Private. That's just Mia Murphy.
Mia Murphy had been with the child. She left Catholic Charities, Judge, and went to another entity.
She has a private practice now.
So is Colton still seeing that counselor?
Yes.
Yes.
Okay. How often?
Once a week.
All right.
And I think it was next week they wanted to start a joint session with Greg and Colton.
Okay. All right. Well, the court would suggest that Mr. Adair follow up with that counselor and inquire when they can commence joint counseling to work through differences. It's clear from the report of Ms. Scott that these two parents are creating the problems for Colton. If he's got the reason he's counseling because the two parents, you have different parenting styles, which is understood, but obviously it's creating problems for this young teenager. Colton's at a very critical age 13. He doesn't need the drama from both mom and dad. It's really unfortunate that you're creating this for him. All right. Anything further this morning, Mr. Godfrey or Mr. Kazmarek?
No, Judge.
No.
Ms. Rorka, you've heard the recommendation and you participate in the discussion with Mr. Pratt. Is there anything you wish to add?
Your Honor, I did. I met with Colton. I also had a very lengthy conversation with Ms. Murphy yesterday afternoon. I believe a big problem here is the lack of co-parenting and communication. I think that all appointments being added to AppClose to that shared calendar, it is my hope that that will alleviate that issue. I have heard directly from Colton that there are disparaging remarks that continue to be made, even though it's something that's been discussed, I think, in every hearing that I have been part of, and I'm sure prior even to my involvement. From Colton's perspective, that comes more frequently from dad than from mom. That is something that I believe that Ms. Murphy will be addressing in those joint counseling sessions with Colton and Mr. Adair. I'm hopeful that they will be able to make some progress and their relationship will improve through that. As far as the recommendation for the parenting time to remain as ordered, I think there could potentially be some benefit while Mr. Adair and Colton are continuing, are working through that counseling to have a little more breathing room, so to speak. But that, as far as a specific recommendation from the counselor, that was not something that she would not typically make a recommendation regarding a specific or a set parenting time schedule in this instance. I do know that that is Colton's wish, which is something I certainly take into consideration when making any recommendations. But I think all things considered, for the time being, if the court is not inclined to reduce that parenting time, I guess, on a short-term basis for the counseling appointments to take place and there to be some progress, then I would agree with the recommendation.
All right, thank you, Ms. Rorka. Ms. Jenkins, Mr. Adair, the one thing that does stand out from Ms. Scott's report to this court is that Colton feels like he's really in the middle. The two of you are putting him in the middle of this dispute. So you need to co-parent. If you want him to do well in life and get through high school, you need to start communicating, co-parenting this child you brought into this world. The two of you are the ones that are creating all his problems. Hey, so at this point in time, having reviewed Ms. Scott's report and the recommendation, the court will adopt the recommendation of Mr. Pratt. Week on, week off parent time will continue. We'll review this on May 8th, 8:30 a.m. and refrain, both of you, from making any negative comments about the other parent in the presence of Colton. It's wrong. With that, that will conclude this matter. Thank you, Mr. Pratt. Everyone can zoom out and have a good rest of the day.
Thank you, Your Honor.
Thank you, Your Honor.
Thanks, Judge.
Thank you, Judge.
The record of this matter is before the court on the plaintiff Carly Carpenter's objection to roughly recommended order awarding the party legal joint physical custody to your minor child with equal week on, week off parenting time. This hearing is being conducted via Zoom. Your Carly Carpenter, is that correct, ma'am?
Yes.
Okay, and sir, you're Stephen Jackson?
Yes, sir.
All right. The two of you have conferred with Ms. Andrus this morning. We'll soon be provided with court with a recommendation. I'm sorry, there it is. The recommendation of Ms. Andrus for the front of the court is that the roughly recommended order be adopted but modified as follows. Mother shall have parenting time every Monday and Tuesday. Father shall have parenting time every Wednesday and Thursday. And the two of you will alternate weekends from Friday after school or 3 p.m. if there's no school until Sunday at 6 p.m. The father's weekend begins February 16th, which is Friday of this week after school. And the mother's weekend begins February 23rd, the following weekend. In addition, the parties shall have parenting time at such other times as the two of you can agree. If you reach an agreement on parenting time or holidays outside this order, then they should put that in writing via text or email. The party beginning parenting time shall be in charge of picking up the minor child. The mother shall claim the minor child as a dependent for tax purposes on odd years. Father shall claim the minor child as a dependent for tax purposes on even years. It's good that we address that now than at a later point in time. So thank you, Ms. Andrus, for covering that with the parties. So that is the recommendation, Mr. Jackson and Ms. Carpenter. So with the court adopting this, you would have joint physical. And actually, this court does not this court does not put out emphasis on joint physical. The reality is joint legal means you share equal in any major decision concerning the welfare of your child, such as elective surgery, health. You need to share information. If he goes to the emergency room, you got to notify the other parent immediately. And you need to, if you cannot reach agreement on things like health and education and religion, then the court makes those decisions. And hopefully you can agree upon those. And joint physical means that that person makes the day-to-day decision. So whoever has parenting time, you decide what time your child's going to bed, what he has for dinner, things of that nature, day-to-day decisions. So if the court adopts this, you'll have joint physical, and specific parenting time, which is relatively equal, but not week on, week off. So Ms. Carpenter, do you understand the recommendation this morning?
Yeah.
Do you have any objection to the court adopting this recommendation as an order of the court?
No.
Okay. Mr. Jackson, do you understand the recommendation?
Yes.
Do you have any objection to the court adopting the recommendation?
No, sir.
Of course, as circumstances change, either one of you can always petition the court to modify parenting time. As your child gets older and circumstances change, someone moves, you got different employment, you can't be there for the child, someone can always petition to modify parenting time. It's always subject to modification upon a change of circumstances. But the reality is, if you want your son to thrive and do well in life, you need to be on the same page. Communication is the key. It's really the key. There's enough challenges in life to make it good for each other and your son. And Ms. Carpenter, you are the mother of the minor child Romeo. Is that correct?
Yes.
Do you believe this agreement is in the best interest of your son at this point in time in his life?
I'm a little worried about it, but I'm hoping it will be good.
You're asking the court to adopt the recommendation, correct?
Yes.
All right. The court obviously will take from that suggests the court to adopt the recommendation that you believe that at this point in time in his life, it's in his best interest. Mr. Jackson, state your name for the record.
Stephen Jackson.
Mr. Jackson, you're the father of the minor child Romeo. Is that correct?
Yes.
Do you believe this recommendation is in the best interest of your son?
Yes, sir.
Do either of you have any questions for the court?
No.
The only question I have, would I have to go on my own and file a motion when it comes to my child support and everything like that, or is that an automatic change, or how does that work?
Well, it appears that a child support order was entered $820 per month effective January 1st, 2024. That order's been entered. So
no, right. They told me that it would change once I was able to get physical joint custody and everything was easy.
And Ms. Anderson, I don't know if you could address that. I don't know the recommendation. I don't know what that was based upon. And it looks like Mr. Jackson was only given 75 overnights.
Correct. That was based on the judgment of support.
Okay.
Overnights. So again, I can, if parties are agreement, because again, today was only regarding the objection to the recommendation for custody and parenting time. So if they're agreement, I can put child support be referred to the front of the court. If not, he'll have to file a child support motion.
Okay. Do you have time to talk to them this morning and based on their incomes, maybe run it and see what difference it would make? Based on overnights, it'll make a little bit of difference, Mr. Jackson, not a significant amount.
Mm-hmm. And then I also just had another child on the 14th. So I know that kind of factors in also.
Well, again, there's more involved. Maybe we should refer it then. Perhaps, Ms. Anderson, maybe we just add to your recommendation that the issue of child support can we possibly add that to this recommended order this morning? Might be perhaps the best way to address this. It appears that Ms. Anderson is frozen up. We'll wait for her to reappear. So we're going to ask that question. Yes, if we can put this in this order that the issue of child support is referred in front of the court, then we can eliminate having to file a motion. Ms. Andrus, is it possible we can squeeze in a sentence in here that the issue of child support be referred in front of the court?
I can do that, Your Honor.
Okay. All right, so we'll put this, we'll put a sentence in here, Mr. Jackson, Ms. Carpenter, that the issue of child support is referred in front of the court for investigation recommendation. You both get a copy of the written recommendation. If either of you has an objection, you got to file a written objection within 21 days. If you do not, it'll become an automatic order of the court. If either party objects to it, then it'll come back for his court to make a decision.
Okay.
But again, obviously you owe the $820 for the month of January, Mr. Carpenter, so you need to make that payment.
Mm-hmm. Yeah, no, they take everything out of my checks, and then I paid $855 at the end of January.
Okay. All right. Anything further from either one of you?
Nope.
Ms. Carpenter?
Well, now, is that just, are you trying to get all these days so that your child support can be changed? Is that what this is about?
This is about my son having me in his life.
Well, I want life, but using me.
This isn't an argument about money. This is about my son being around and everything like that.
Okay. Right. The court would like to assume that he's not doing this for ulterior motives, Ms. Carpenter. But the reality is yes, there'll be a slight modification or reduction because of the relatively equal overnights. And the court is hoping he's not doing this. And we'll see how active a father he is. Obviously, children are best served if they spend as much time with each parent as possible. And if Mr. Jackson is not exercising parenting time, he's leaving it with his mother or his girlfriend, and that's obviously based to modify parenting time. So we'll give Mr. Jackson to see how he does. If he's going to really invest in this child's life, hopefully he will. So the court's going to assume he's got the proper motive for doing this, and time will tell.
Yeah, no, I've always been a big part of my son's life, so this isn't something new or anything like that. I've always been a major part of my son's life. And
again, obviously, I know your work schedule, but obviously this parenting time is for you. It's not for your girlfriend or your mother or your sister, Mr. Jackson. You need to be there.
No, right, exactly. And I assume the same for her.
Okay. All right. That will conclude hearing. You'll be emailed a copy of this order, and hopefully we can move forward in a positive fashion for your child's benefit. Obviously, you've always got to talk positively about the other parent in the presence of your child. That's real critical.
Mm-hmm.
Little things are important. Mr. Jackson, you should always make sure Romeo has a card for his mother on Mother's Day. Likewise, Ms. Carpenter should always make sure Romeo has a Father's Day card for his father on Father's Day. Those little things mean a lot to children. They really do.
Oh, yeah. No, we've always been good with doing stuff like that.
Okay. All right. That concludes this matter. We're going to add the language about the referral to the child support to the front of the court for recommendation. With that, I'll conclude the matter. You can all both zoom out. Have a good rest of the day.
All right. You guys have a good day.
Thank you.
Welcome.
That order shall be in your queue very shortly.
Thank you. For the record, this matter is before the court in the defendant's motion for an order extending parenting time and other relief, as well as the plaintiff's motion to disqualify defendant's attorney, Mr. Bruce, from representing the plaintiff due to an alleged conflict. This hearing is being conducted via Zoom. President Attorney Stephen Jednick representing the plaintiff's mother, Janet Buxton. Ms. Buxton appears to be present. In addition, Attorney Ron Bruce is present representing defendant Michael Buxton. Mr. Buxton appears to be present. Good morning, everyone.
Good morning.
Good morning, sir.
The court would note for the record before we begin that this court did enter an ex parte order on February 5, 2024, which granted temporary possession of the two children of the parties to the defendant father. And for that, the defendant mother's parenting time be suspended until we come to court today. The parties have conferred with Ms. LaPrade, who is part of the court's final recommendation. With respect to Emma, now the 18-year-old is 18-year-old graduate from high school.
No,
No. I'm sorry.
No, she's not.
Ms. LaPrade, will the court have jurisdiction over the 18-year-old until the 18-year-old graduates from high school in the spring?
We do, but with an 18-year-old, I don't usually say where they'll be because they have a little more control than the court does because they're 18. No one's going to force them to go back to one parent or the other. That's why I only addressed Emma.
Well, all right. So this recommendation addresses only Emma for that reason. The recommendation is that fathers shall continue to have extended parenting time with Emma. Our mother shall have parenting time every other weekend, Friday after school, and returning to Emma to school Monday morning, beginning February 17th, 2024. Emma shall attend in-person school. Both parties shall communicate all payments for the minor child. Neither party shall discuss this case or the proceeding with the minor child. Neither party shall make any disparaging remarks about the other parent or the child. It's probably the most hurtful thing that can be said to a child. It's a negative comment about the other parent. That is the recommendation. Mr. Jennings, this recommendation agreeable with your client this morning?
In part, it's not.
Okay. Okay, which part is not?
The adjustment in parenting time.
Judge, I didn't know if the court would want to deal with that disqualification first. Or...
Okay, I'm noting the current parenting time is Dad has just alternating weekends and every Thursday overnights. Okay, so we'll address that. Okay, we can address the plaintiff's motion to disqualify defendant's attorney, Mr. Bruce.
Mr. Jednak's motion, I can go first if you prefer.
I've read the motion, and the court's of the opinion the court's not going to make that call. Obviously, there could be a complaint. Mr. Bruce, if you think that there's a conflict in your part, having previously represented Mrs. Buxton, and you have some background regarding her prior health conditions, then that's you need to make that call.
Okay.
So do you believe, are you still going to continue to represent Ms. Buxton? Do you believe there's a conflict that requires you to step down?
I don't, Judge. As we discussed it briefly with a friend of the court, I don't have any recollection of representing Ms. Buxton. She's not in our client management program, nor is her name referenced on my server for any letters or documents. I reached out to Mr. Jednak to reach out to his client. She didn't have any documentation pertaining to me representing her. So I don't think I did represent her. I'm not saying it could be wrong, but I certainly don't have any recollection, don't have any personal knowledge. And I believe the representation alleged is substantially different than what's currently before the court. So I don't think it would be relevant regardless. So I think I'm fine representing Mr. Buxton. I did talk to him as well. This was alleged to have occurred in 2014. At that time, Mr. Calkins was representing Mr. Buxton in a divorce. I find it hard to believe that she would reach out to me to represent her, given those facts. So I think I'm fine with representing Mr. Buxton at this time.
Very well. The basis for Mr. Jednak's motion on behalf of Ms. Buxton is that Mr. Bruce allegedly represented Ms. Buxton in back in 2014 on a assault of civil action, and that her mental health and past behavior was relevant to that prior case as well as the current case. So that's the sum of substance. Mr. Jednak, Mr. Bruce says he has no recollection, no knowledge of Ms. Buxton's prior health, mental or physical, otherwise. Do you want to add anything to that, Mr. Jednak?
Not really. The court knows Ms. Buxton's position. I know Mr. Bruce's position. She's adamant that the prior representation and that information was shared. So I just simply asked the court to make a ruling on it.
Well, the court's not going to make a ruling. That's something that if Mr. Bruce feels ethically there's an issue, he should not to recuse himself. Ms. Buxton can always file a complaint if she wants with the Attorney Grievance Commission. And Mr. Bruce, a lot of times, attorneys just don't want to go there, but I'll leave that between you and Ms. Buxton. Your position is noted for the record, Mr. Bruce.
Well, like I said, I don't believe there's a conflict.
I'm sorry? Okay, you don't believe there's conflict?
I don't believe there's any issue with my representation, Mr. Buxton.
Okay, and you have no recollection or no records regarding the past health of Ms. Buxton? You do not recall representing her civil action? 2014 was, 9 years ago, 10 years ago, so it sometime has transpired, but you have no records, no recollection of her prior health condition?
No recollection, no file, nothing.
Okay. All right, so again, the court will not address that matter. Mr. Jenik, Mr. Bruce, with that to council. All right, so Mr. Jenik, you're opposed this recommendation. You do not believe there should be any modification of parenting time?
That's correct.
All right. Do we put Emma in the middle, have Emma interviewed? Obviously, there's some pretty serious concerning allegations here. That's why the court entered the ex parte order.
Well, and that's the problem. The parties have been aware of Emma's mental health issues, and she's been treated for a while. And it's not the first time she made ideations. The concern is, how did it tie back to mom? I mean, per the motion, it was the oldest daughter reporting this to the school, Allie. I'm not even sure if there was communication between the school and Emma about it. Then the child's later taken to the hospital. Now, dad doesn't, or the school and dad don't notify mom of this, and she has the right to know. Goes to the hospital for a couple hours. She's not admitted. She's discharged and told to follow up with her mental health worker. And as I don't know how this ties back to mom or how mom is at fault. She's been a part and parcel to treatment all this time. And even more stunning, since the temporary order was entered, dad's taken upon himself to switch the kids to virtual school, cancel appointments. He's taken a lot of liberties with the legal custody arrangement of these parties and these kids, just on the basis of a temporary possession order, which is why some of those aspects are addressed in the recommendation. But there's not even a motion to modify custody before the court. It's just as ex parte, and the recommendations essentially flipping the dynamic where dad went from Thursdays and every other weekend to mom's getting every other weekend, and there hasn't really been a showing that mom's at fault. So the ex parte order, as it relates to cutting back on mom's parenting time, is bizarre and ridiculous under those facts, and I think it needs to be set aside. Mr. Bruce is free to file a motion to modify custody that could be heard by the court, but I don't think an emergency is justified at this point to allow this ex parte to continue to cut off mom's contact with Emma.
Is Emma currently involved in counseling, Mr. Jenik?
She is. Okay. And she has been, and she continues to.
Mr. Bruce, do you have any letters from the counselor?
The counselor wouldn't provide a letter other than the dates of counseling. He said he doesn't involve himself in custody disputes. His child has been in counseling several, I think, once a week, the last couple of weeks since the ex parte was entered.
So the only real substantive allegation we have here is that mom was driving the car with Emma as a passenger, and mom's behavior became erratic. She threatened to drive off the road.
That was
which is denied. There's no CPS investigation. There's no police investigation. I said that this ex parte, if it continues, it's flipping the custody dynamic completely, and it's completely unjustified as our position.
Well, Judge, obviously my client doesn't think it's bizarre or ridiculous that the order was entered. Both the kids, I mean, they are older. They're 16 and 18. Both of them went to dad, said mom's behavior was erratic, indicated that, they were more comfortable staying at dad's house. The school contacted my client. It's not my client calling CPS. They indicated that Emma was having suicidal thoughts. He took the child to the hospital. Hospital said, take him to the counselor. He's done everything they requested. If the court, I think if the court were to interview Emma or both of them at that point, I think they would indicate that they would prefer to stay at dad's house. I think Emma indicated to the counselor, according to my client, that she feels 100 times better staying at dad's house mental health wise. I think that's the concern, is that the younger daughter, she's 16, she's going to be 17 in May or June, I believe. She's obviously having mental health issues. I don't think anyone disputes that. I think she's more comfortable staying at dad's house. At least I would suggest doing it for the interim and maybe scheduling a review if the court not wanting to make this permanent. But I think for now, obviously the child is having mental health issues, and I think it's appropriate that dad keep her for the time being.
Yeah, no one minimizes the mental health issues, and both parties have been part of treatment. Frankly, until this order, mom's been 90% of the treatment and taking Emma to appointments and things like that. And again, I'm trying to understand how these ideations relate back to mom, where mom is a danger to the kids, where the ex parte is justified. She's going to continue to be a party and to the treatment and care that has been going on, but the emergency is not justified. In fact, Mr. Bruce kind of put his finger on it, that this is really based on the children's preference about where they want to stay, but that doesn't justify the ex parte nature of this. A motion for custody needs to be filed, and this needs to be heard by the court through the proper channels.
I understand the court believes ex parte relief was appropriate based upon the allegations the court was presented with Mr. Jednick, but obviously the court has now heard from the other side, and that's why this court always schedules a quick hearing if I enter ex parte relief. And the court agrees. I mean, there's obviously Emma's got mental health issues. Doesn't necessarily mean mom's got mental health issues. The court has no documentation of relevance. Mr. Bruce, why did Mr. Buxton change the school for the two children?
Well, basically, she did have some physical issues with in-person school. It's my understanding that she passed out in school a couple times. She indicated that she felt it was better for her mental health to attend the online school. She's been in it for 2 weeks, not had any issues. Dad's been following up on a daily basis.
And Mr. Buxton did not consult mother, correct? He just unilaterally made that change?
Correct.
That's clearly inappropriate. This court's opinion, unless we have some documentation from a counselor, the children are better off in person at school rather than be isolated at home. Mr. Buxton had no authority to unilaterally change the school from without consultation with mother from in person to online. At this point in time, the court's going to set aside the ex parte order. For time will continue as previously ordered, but the court will have Emma shall be interviewed by Ms. LaPrade or Ms. Scott. Who do you suggest, Ms. LaPrade? Who will be the quickest to be available to interview Emma? And I don't know if we should also interview the older child, the 18-year-old, just to get maybe separately.
Children can be here at 4 o'clock today. I can do that, Your Honor.
Okay. Okay, who can, Mr. Buxton, can you bring Emma to the front of the court at 4 o'clock this afternoon?
Yes, sir.
Okay. An interview of probably, what, 15 minutes, Mr. Brad?
Yes, sir.
Counsel, are you available if we maybe zoomed in at 4:30? Or is that too late? Should we put that over to Friday?
Well, let me ask, if the court's setting it aside, is that restoring the previous parenting time that was ordered? Because technically it'd be mom's time, and we need to talk about the logistics of that.
I think I'm going to put that order on hold right now since Mr. LaPrade is so readily available to interview her at 4:30 today. So I'm going to put that on hold right now, and I want to hear from Mr. LaPrade before the court makes a definitive decision.
So I could zoom back in at 4:30, so since we could hopefully
yes,
settle that today.
Are you available?
I could be here 4:30.
Mr. Bruce?
Yes.
All right, Mr. Bruce Buxton, are you both available at 4:30?
Yes.
And Mr. Buxton, you can zoom in, of course, from the bring your phone. You can zoom in from the courthouse. Obviously, Emma should not be in your presence. So bring Emma down. She'll meet with Ms. LaPrade at 4 o'clock. Do not discuss this case with her. Just to say that the court wants her to be interviewed.
Yes.
Ms. LaPrade, do you think we'd be available at 4:30?
I will be available at 4:30, Your Honor. Yes.
Okay, Sarah, can you be here at 4:30? All right. So the court will just simply put this over to 4:30, and thank you, Mr. LaPrade, for being so readily available to interview Emma on short notice. The court will address this motion for parenting time after the interview is conducted, and we reappear. For the record, this matter is before the court on the objections filed by both parties. First of all, the objections of the plaintiff, Kaylee Edmondson, to a recommended order that the parties shall continue to share legal joint physical custody of their two children with equal parenting time. In addition, what's before the court is also an objection filed by the defendant, Father Troy Laidler, to a recommended order of child support. This hearing is being conducted via Zoom. You are Kaylee Edmondson, is that correct, ma'am?
Yes.
Okay, and Troy Laidler is also present. The two of you have conferred at length with Ms. Brower in front of the court this morning, who has provided the court the following recommendation. If the court adopts this, it'll become an order of the court. The recommendation is that the referee recommend order be rescinded and canceled. And you're asking the court to do that, Ms. Edmondson, to rescind and cancel that recommend order. And that the parenting time shall be, in lieu of that, this will be the order, that the father's parenting time should be on a 2-week rotation. Week 1 will commence Friday after school. A 6 and a 4-year-old, or 5 p.m. if there's no school. Then dad will take the children back to school Tuesday morning, or 8 a.m. to you if there's no school. Week 2 for dad will be Friday after school, or 5 p.m. for no school, to Monday to school, or 8 a.m. if no school. If there's no school, the paternal grandmother or great-grandmother shall transport the children to and from mother's home. Mother shall stay in the home during the exchange. Father's agent or his grandmother or great-grandmother shall also stay in their vehicle. Children shall be dropped off the curb or driveway to walk into mom's home. The party shall adopt the friendly court holiday schedule, absent an agreement to the contrary. Each party shall have 1 phone call per day at 7 p.m. when the children are not in their care. Mother shall initiate her calls to the paternal grandmother. Father shall initiate his calls to the plaintiff's sister. There should be no disparaging remarks from either of you or any third party regarding in the presence of the children about the other parent, and there should be no corporal punishment, no physical punishment. And if the minor child is sick, the other parent should be notified immediately. Further, that child support shall be modified and shall be in the amount of $222 per month, effective January 1, 2024.
I don't.
That is a recommendation. Ms. Edmondson, do you understand the recommendation?
I understand the recommendation, but I don't agree to it.
Okay. What is your what is it that you don't agree with?
I don't agree with the child support.
Okay. Okay, unless you can show that Mr. Laidler's income is inaccurate. It's a black and white, it's a formula based on incomes. And child support can go up and down. As Mr. Laidler, if you get laid off, you have no income, Mr. Laidler has an increase, we can always modify child support upon changing circumstances. But there's a very little wiggle room in child support. It's based upon incomes. So you claim that Mr. Laidler is misrepresenting his income?
He might be. He may be.
I'm sorry, Miss Edmondson, who else is present in your room?
No, nobody's present. They're not in the room. They're in another room. I'm in the kitchen.
Okay, well, I heard some other person speak up, and this is between you and Mr. Laidler. We shouldn't have third parties putting their 2 cents in. So if you need to close the kitchen door, we don't want input from any third parties.
The kitchen is wide open. It's connected. It's connected to the living room.
Well, the court's concerned when you have a third party telling you what to agree to and what not to agree to.
No,
so,
not.
They
weren't even speaking to me.
Okay. Mr. Laidler, did you accurately report your income to Ms. Brower this morning?
Yes, sir.
Ms. Edmondson, what evidence do you have that Mr. Laidler is not providing accurate information?
Before this motion, he agreed to giving me $5. He agreed to that, and then on a piece of paper, he said that his hours changed, which I think he purposely cut his hours for he doesn't have to financially help me with those children. I also do believe that he wants the children more for selfish reasons, where he doesn't have to help me financially.
Right. Well, hold on. Let's talk about child support right now. Parenting time is another issue. Let's talk about child support.
That's what I'm saying. I'm using that as an example for the child support.
The original child support recommendation was $501. And Ms. Brower, have you reviewed Mr. McKee's recommendation, the basis for that recommendation?
Yes, Your Honor.
Well, what's the difference between what's being reported today and what's reported to Mr. McKee?
I use the same income, health insurance, and childcare that Mr. McKee did. I modified it to 185 overnights for dad versus 156 that Mr. McKee used, and it did reduce the child support to $222.
Okay. Right. Well, Ms. Edmondson, the court can adopt the recommendation relative to child support if you believe that there is other income there, and then you can file a motion to change that. But that's what the court's can orders will be is 222, commencing January 1st, 2024. So let's now talk about parenting time. You disagree with the parenting time recommendation as well?
Sorry, can you repeat that?
The court is adopting the child support recommendation of 222 a month beginning January 1st. So let's now talk about parenting time. Do you also disagree with this parenting time recommendation as well? Is that correct?
Yes, I do disagree with it.
Okay. Now, prior to the recent action, what was Mr. Laidler's parenting time? Mr. Laidler, you had every Sunday morning and took the children to, you had every weekend, correct? Sunday morning to school on Tuesday morning, is that correct?
Yes, sir.
Okay, the court noted that was a past practice, and you also had parenting time every Thursday overnight. Is that correct?
Yes.
Would you agree, Ms. Edmondson, that was the practice in the past until after you separated? Mr. Laidler had every weekend, Sunday to Tuesday, and also every Thursday overnight?
Yes, that's what he had. And also, but before that, I mean, he didn't really care to have those days either, because there will be times where he will choose partying over being with kids. So. Well,
but obviously, if he's not following this parenting time schedule, he's not there with the children. Are you off work on Mondays and Tuesdays, Mr. Laidler?
Did you say, was I off Mondays and Tuesdays?
Will you be? This is not parenting time for your mother. This is parenting time for you. Are you off work on Mondays and Tuesdays?
No.
All right. Do you work? What about Mondays?
Yes, I work Mondays.
Okay, but again, so where are the children going to be? Should they be with mom rather than you?
To be at school. I drop them off at school, then go to work.
Okay, well, that's right. The youngest one is in preschool or daycare. Is that correct?
They're both in school.
Okay, they're both in the same facility?
Yes, same school.
All right. So you'll be able to get them to school, and you'll also be available to pick them up?
Yes.
All right. All right. I guess that I forgot that they're school age. So this recommendation is not far off, Ms. Edmondson, what the two of you previously practiced after you separated. Dad had every weekend, basically, from Sunday morning to Tuesday morning to school, as I understand it, and every Thursday overnight. This just simply gives them long weekends.
He don't. He does. He works Monday and Tuesday. Sometimes he doesn't even get off until late at night. So those days, they're with his mom and his grandma. And while I'm at home.
All right. What about that, Mr. Laidler? How often are you not home when the kids get out of school?
He doesn't pick me up.
With my old job, yeah, I would work long hours. But with my new job where I'm at now, I get off at 2:45.
Okay, so you'll be home in the evenings on Monday and Tuesday. Is that correct? On Mondays?
Yes, with my new job, yes.
So you'll be home, you'll be home Friday evenings as well as Monday evenings, correct?
Yes, sir.
Do you work weekends?
Every other Saturday.
Okay. And who's going to watch the children every other Saturday when you're working?
It'll be my grandmother and my mother. They both help.
Okay, they should be with mother. Miss Edmondson, do you work on Saturdays?
No.
Okay. Miss Brower, is there some way we can modify this that or maybe just add a sentence that on the course of claim to adopt the recommendation, but maybe alternate Saturdays when Mr. Laidler is working, the children shall be returned to mother. I know it's a lot of going back and forth. Mr. Laidler, you willing to make this work? And the Saturdays that you are working, you will notify, you will return the children to Miss Edmondson.
Yes, if I could get a weekday in replacement of that Saturday.
Well, we're not going to bounce kids around. I mean, let's try to. It's sort of complicated right now. I'm not going to overcomplicate this. Any thoughts, Ms. Brower?
Your Honor, we could modify days where the parties rotate Saturdays instead of Tuesday, and that would alleviate the issue.
That might be the that perhaps is a reasonable solution. So in other words, during the week that Mr. Laidler is working on Saturday, the child will be with mom. So dad's weekends would be Friday after school until Monday to school. Is that what you're suggesting?
No, Your Honor. I would suggest father have week 1, Wednesday after school to Sunday morning. And week 2 would be Wednesday after school to Saturday morning before he begins work.
So both weeks would be Wednesday after school. You can pick them up from school then, Mr. Laidler?
Yes.
Okay. And what time do you get out of school?
3:15.
Okay. And you can be ready there to pick them up at 3:15?
Yes, sir.
And then week 1, you'd return the children to mom on Sunday morning when you're not working. When you're working, you return the children to mom on Saturday morning.
Okay.
And if you go into work real early, obviously let the kids sleep in, and then if you're working, then we'll establish a time that you will have the children return to mom on your Saturdays that you're working. And if you're working, your mother or grandmother shall transport the children to mother's home. We should perhaps set a time on Saturday and Sunday, Ms. Brower. Perhaps 9 o'clock, 9 a.m. Would that work with the children? 9 o'clock on Saturday would return to mom if dad's working. Otherwise, it'd be 9 o'clock on Sunday.
Yes, sir.
Right. Okay, just hold on, Mrs. Emerson. Mrs. Brower's she's been gracious enough to reduce this to writing. So in other words, Ms. Brower, the suggestion is, recommendation is, and I appreciate your help, is on week 1, dad will have plenty of time Wednesday after school until Sunday morning, 9 o'clock. Week 2, dad will have plenty of time Wednesday after school until Saturday at 9 a.m., assuming that he's working that Saturday.
Correct. Mr. Laidler, which Saturday are you working? This Saturday or next?
This coming up would be next. It'd be next Saturday. I'll be working that day. Not this coming.
24th? The 24th? That'd be the 24th of February, correct, Mr. Laidler?
Yes.
All right. So this weekend, Mr. Laidler would have parenting time. Well, actually, today's Wednesday. So, you recommend this take effect immediately, Ms. Brower, that Mr. Laidler will pick up the children from school today?
Yes, Your Honor.
No reason why we shouldn't. So, do you understand what's being discussed and recommended, Ms. Edmondson?
No.
Okay. So, the court's going to order parenting time as follows. If you have a problem with it, you can talk to an attorney. The father's parenting time will be week 1, which will start today. So dad will pick up the children from school today at 4 o'clock. Dad, Mr. Laidler, do you have clothing for the children?
Yes, sir.
Do you have beds for the children?
Yes, sir.
Do you have car seats?
Yes, sir.
All right. And obviously, the 6-year-old will have homework. You need to make sure you go through the backpack and review what needs to be done for the following day of school. So this will be the week 1. Dad will pick up today from school, and he will return the children to mom on Sunday at 9 a.m. The following week, Dad will have parenting time on Wednesday. That's the 21st of February after school, and he'll return to mom on Saturday, the 24th of February at 9 a.m. because he's working that day. And you'll alternate that every week. So do you understand the recommendation, Miss Edmondson? Miss Edmondson?
No, I don't understand that because that means that y'all just granted him 5 days with his children. I didn't even get to see my children this week. So I'm literally about to go another 5 days without seeing my children.
Okay. Is that correct, Mr. Lathler? You've had children for the last 5 days?
Yes.
Yes, I had them.
All right, so we'll start this. That's a good point. So, Mr. Lathler, we're going to start this the following Wednesday, the 21st. I mean, obviously, if you've had children the last 5 days, the children will start your parenting time on the 21st of February. So you're going to pick them up after school on Wednesday, 21st. You're going to deliver to mom on Saturday morning, the 24th.
Okay.
So mom will pick up the kids from school today. Your parenting time will start a week from today, Mr. Lathler. Understood?
Yes, sir.
Okay, Miss Edmondson, I wasn't aware that the children have been with Dad the last 5 days. Perhaps we should also indicate in the recommended order, Ms. Sparrow, that the party shall share joint legal. So we're just going to do just joint legal, and the parenting time is set forth in the recommendation.
Yes, Your Honor.
The last order of July 19th reference, the mom has sole legal, but there's been, it appears that the parties should not to agree upon joint legal, make equal decisions regarding their welfare. All right, Miss Edmondson, again, I understand you may not agree with this. And obviously, if the two of you can be on the same page as parents, you know what's best for your schedule and that of your children. Work together, co-parent your children. You want them to do well in life. There's enough challenges in life. Make things good for each other and the children. So if, in fact, you two of you agree to modify parenting time, you can come back before this court and I'll modify the order. But if you cannot agree, then the court has to decide these matters. And you don't want the court raising your children. So until further the court, parenting time will be as follows. Dad will have on a 2-week rotating basis. Dad's parenting time will start on Wednesday, a week from today. That's February 21st. After school, pick them up and return to mom at 9 a.m. a Saturday morning, the 24th. The following week, Dad will have parenting time on Wednesday, the 28th, until Sunday, the 20th, that'll be March 3rd on Sunday.
Is there any chance that it can change if my circumstance?
I'm sorry, is there possibly can change your circumstances?
Yeah.
Yes, obviously, if this does not work out, you can file a petition with the court saying, Judge, it's not working out. We want to modify it.
No, I'm saying if my circumstances change, will this court order change?
Not automatically. You need to present to the court your change of circumstances so that Dad's aware of the change of circumstances and we can discuss that together.
Also, y'all granted him 5 days out of the week, and I only get 4. How are we splitting 7 days throughout?
Well, 1 week he's only going to have 3 nights: Wednesday, Thursday, and Friday, and you'll have 4 nights that week.
Okay, I didn't hear you correctly.
Well, for example, we're going to start a week from Wednesday. Okay, the 21st, if you look at the calendar, a week from today, and he'll pick up after school on Wednesday. He'll have Wednesday night, Thursday night, Friday night. He's going to bring back to you a Saturday morning because he's working, 9 a.m. And then the following week, he'll have 4 nights and you'll have 3 nights. So it's relatively equal parenting time. If, in fact, this does not work, either one of you can petition the court to modify it. But the children deserve to have as much time with each parent as possible. And it appears in the past, Mr. Layla's had at least 3 overnights per week. Sunday, Monday, and Thursdays. So it's not significantly different from what you practiced in the past. Again, each party shall have 1 phone call per day. You can call the children when their dads care, or dad. You can they should call it the paternal. You can call the plaintiff's Miss Edmondson's sister, and Miss Edmondson. You can call the paternal grandmother. You got her phone number. You can call at 7 o'clock to talk with the children.
So I don't have a phone anymore. I can't really do that. So it's okay.
Well, maybe you can borrow a phone.
I'm not
borrow a phone.
I'm not going to borrow nobody's phone. No, it's okay because I'll get away.
Okay. All right. So please work together. Miss Edmondson, Mr. Laidler, work together to make life a lot easier for each other and the children. All right. Do you have any questions about this schedule, Mr. Laidler?
No, sir.
And Miss Edmondson, do you have any further questions?
No.
Okay. If in fact it doesn't work out, either of you can petition the court to modify this. So, Ms. Edmondson, you get forms at the front of the court and talk with your caseworker. You can file a motion in a month from now if it's not working out, and explain to the court why it's not working out, and the court will look at it and modify it if necessary. Okay?
Yep.
Okay. All right. That concludes the marriage. Both zoom out. For the record, this marriage is before the court for entry of a proposed consent judgment divorce. The hearing is being conducted via Zoom. Are you Joshua Green?
Yes, sir.
All right. Good afternoon. And ma'am, you are Kayla Green?
Yes.
Okay. It appears everything is in order. We both approved the proposed judgment. Thank you. Is it true, Mr. Green, that you filed a petition for divorce with this court on or about December 8th, 2023?
Yes, sir.
Is it further true that on the date you filed the complaint that you reside in the county of Monroe for at least 10 days and stay in Michigan at least 6 months?
Yes.
You were a little hesitant. Did you live in Monroe County for 10 days and stay in Michigan 6 months prior to filing?
Yeah, I did.
Okay, we need to
Sorry, it was hard to hear.
Okay. What was the date of your marriage to Kayla Green?
It was, I got my marriage certificate.
Well, what year was it? And your petition doesn't allege.
2017.
Okay,
December
2017. All right. Mr. Green, is it true there's been a breakdown of your marriage relationship to the extent that the opposite match would have been destroyed?
I believe so, yes.
Is there any chance of reconciliation?
No.
Were there any children born or adopted during your marriage?
No, sir.
Is it true you've signed your name to this proposed judgment of divorce?
Yes.
All right. Ms. Green, could you please state your name? Ms. Green, did you hear the testimony of your husband, Joshua, this afternoon?
Yes.
Was his testimony true and accurate to the best of your knowledge?
Yeah.
Are you currently pregnant?
No.
Did you also sign your name to this proposed judgment approving the terms and conditions contained therein?
Yes, I'm being cooperative.
Yeah, I just want to know if in fact that's your signature on this judgment.
Yes.
Okay. All right, I'm going to walk through this with you. You both agreed that spousal support or alimony is not awarded. That's forever barred. You've already divided your personal property, so each will keep the personal property current in your possession and pay any debts thereon. There's no joint debt. Each will pay any debts in their own names. Each will keep their own automobile. There's no real property to be divided. Each will keep their own retirement benefits, whether it's an IRA or pension or 401k. And each should be responsible for their own health insurance hereafter. Do you have any questions for the court, Mr. Green?
No, I do not.
Ms. Green, do you have any questions for the court?
Is health insurance going to be ended today?
You have to check with the current insurer, but normally that the insurance, and I can't be your lawyer, do you have your insurance through your husband's employer?
Yes.
Normally it's good through the end of the month, but Mr. Green needs to check on that. So you want to be careful. If you need any Any medical procedures done between now and then, you probably want to verify that it's covered. Normally, it's good till the end of the month. And
Okay, I did
I
get
think
another. Oh, sorry.
I think Mr. Green has to inform his employer that he's now single. But I guess perhaps wait till the end of the month to do that. I'm sorry, we had a question, another question, Ms. Green?
No, I started, the new insurance for me will start tomorrow.
Oh, okay. Shouldn't be a problem then. All right, so based upon the testimony that's been presented this afternoon, as well as the plaintiff petition filed this matter, the court finds that jurisdiction has been established. The court further finds that there has been a breakdown in the marriage relationship to the extent that the options of matrimony have been destroyed. There's no reasonable chance of reconciliation. Accordingly, it's ordered by this court that the marriage between the parties be and is thereby dissolved. Judgment shall enter granting a divorce from bonds of matrimony. Court will sign the judgment. We'll open mail a copy. Ms. Petrula, you want to take a copy of this judgment to the Secretary of State and Social Security to facilitate the legal change of her last name. Okay?
Okay, thank you.
All right, that concludes. Ready? You can both zoom out and have a good rest of the day.
Her audio's not working.
Yeah, I see she had to unmute herself.
Yes, Your Honor.
Okay.
There she is.
Okay, the two of you are now divorced. Is that correct?
Yes, Your Honor.
You have no children in common?
What's that, Your Honor?
You have no children in common. Is that correct?
Children? We have two.
Oh, you have two children?
Yes, Your Honor.
Okay. How do you currently handle parenting time exchanges?
What's that? Sorry, my headphone cut out there for a minute, Your Honor. I'm sorry. What was that?
How do you currently handle parenting time exchanges?
I drop them off on certain days and she picks them up on certain days. We have it scheduled 8 times out of the month.
So do you drop them off at a third party location?
No, I drop them off at her apartment and then her and her boyfriend drop them off at my trailer. We kind of 50-50 back and forth.
So the two of you do have some contact, correct?
Yes, Your Honor.
All right. So when you exchange parenting time, Mr. Thornburg, Miss Thornburg has to go to your home on West Outer Drive. Is that correct?
Yes, Your Honor.
All right. Well, this PPO has not prevented that.
What's that? I'm sorry.
This perspective has not prevented you from doing that.
Right.
So what problem is this PPO creating you? It's going to expire automatically on July 24th, 2024.
So I
support that this is creating problems for your children.
So I put that into place after the domestic. So I was in fear at the time because of what happened with the domestic incident at my trailer. And then we kind of just worked things out being co-parents, and I just didn't feel like it needed to be in place anymore. I mean, we've been working better separate than we ever have been. And I just didn't feel like it needed to be, still served and stuff like that. So I wanted to drop it so we can continue working as co-parents for the kids.
And Mr. Thornburg, you were the victim of a domestic assault on part of Miss Thornburg. Is that correct?
Yes, Your Honor.
Are you currently fearful of your personal safety and well-being when you exchange your children?
No, Your Honor.
Wait, Ms. Thornburg, what's the status of you were charged with domestic violence. What's the status of that charge?
The domestic was dropped. I had to plead to disturbance of the peace.
Okay, you had patient?
No, I just had to pay a court fine.
Okay. Did you engage in any type of anger management counseling?
I have talked to somebody about it for a few months, and then I just haven't had the money to talk to anybody.
Okay. But you're not required to complete such a program, correct?
No, I'm not.
All right. Would you agree that you're able to co-parent now that you're separated and divorced?
Yes, Your Honor.
And that's right. How old are the children?
Our son is 5 and our daughter is 3.
Okay. I don't know if this domestic violence goes back last summer. I don't know if did that take place in the presence of any of the children?
It did.
Yes, Your Honor, it did. It happened in front of our son.
That's something he's going to remember the rest of his life. Have there been any parenting time complaints filed by either one of you since you've been divorced?
No, Your Honor.
No, Your Honor.
Again, how long when was the divorce finalized?
December 6th of 2023.
All right. So about 2 months.
Yes, Your Honor.
All right, the recorder will reluctantly grant the request and terminate the personal protection order, and hopefully the two of you can co-parent. And then this is not good when a minor child observes two parents involved in physical altercation. It's got to be very upsetting for that child. And hopefully that conduct will not be repeated. If it is, the court will not ever terminate another personal protection order with involving the two of you. So, Ms. Thornburg, if you need assistance with your anger management, get in a counseling program. You do not want to expose your children to any type of aggressive conduct toward their father, and likewise, Mr. Thornburg. But, all right, Mr. Thornburg, you're in order to terminate the personal protection order. You'll both have a copy of this.
Thank you, Your Honor.
All right, good luck to both of you.
Thank you, Your Honor.
Welcome. Okay, you can zoom out.
Court is now in session. Danielle Williams versus Barry Ellison.
For the record, this matter is before the court for review, subsequent to the parties engaging in continuing mediation and discussions with Mr. Josh Walker from the front of the court. This hearing is being conducted via Zoom. Present is Attorney Christina Hills, representing the plaintiff, Mother Danielle Williams. Ms. Williams is present. In addition, Attorney Stacy Dinser is present, representing defendant father Barry Ellison, and Mr. Ellison is present. Good afternoon, everyone.
Good afternoon, Your Honor.
Mr. Walker informs the court the parties have made some progress towards their own agreement this afternoon. Is that correct?
Yes, it is, Your Honor.
Wonderful. Who would like to place that agreement on the record?
I can do that.
Please, Ms. Hills.
Your Honor, the parties have agreed that all communication between the two of them will be civil and respectful. They've agreed that Mr. Ellison gets to take the minor child Sanaya to daddy-daughter dances sponsored by the school each year, and the minor child Sanaya is to be returned to my client immediately after the dance. We are reiterating that communication is to be only through app close. We are also reiterating in a new order that there's to be no disparaging remarks made or allowed to be made by the other party in the presence of the child. And we'll also include inherent rights language once again in this order. Mr. Ellison has agreed to pay to me $1,000 in attorney fee reimbursement. That will be within 60 days of today's date, and that will fully resolve the issue of our claim for attorney fees. And that's the entire agreement for today.
I would add, though, that the disparaging remarks, right now, it just says no disparaging remarks in front of the child or in social media. I know that the civil and respectful should cover, but if you're going to reboot the disparaging remarks, it should be in any venue, through any media. Just no disparaging remarks, period. If you can't say something nice, don't say anything.
That's fine. We can make that apply to
I just their text messages
in general.
Yeah, we just don't need any more gas on the fire.
Court would fully agree, so perhaps that language can be a little broader, Ms. Hills.
Yes, Your Honor.
All right, other than that clarification, Ms. Dinser, Ms. Hills accurately stated your client's agreement.
Yes, Your Honor.
Right, wonderful. It's wonderful to see these two can move forward in co-parenting. Right, Ms. Williams, Mr. Ellison, can you both please raise your right hand to be sworn, please? Do you both solemnly swear or affirm that the testimony about to give this man will be the truth, the whole truth, nothing but the truth, so help you God?
Yes.
Can you unmute yourself, Ms. Williams?
I do. Can you hear me?
Yes, we can hear you, Mr. Ellison. Ms. Williams needs to unmute herself. We cannot hear her.
Yeah, I did. I don't know what's going on.
Okay, Ms. Williams, you affirm to tell the truth?
Yes, I do.
Thank you. All right, so Ms. Hills, you want to give us Ms. Williams, please?
Yes, Your Honor. Ms. Williams, will you state your name for the record, please?
Danielle Marie Williams.
And have you heard the agreement which I have just placed on the record and which Ms. Dinser clarified?
I did.
We arrived at that agreement through mediation with Mr. Walker this afternoon. Is that correct?
That is correct.
You were a participant in that mediation?
Yes, I was.
And do you understand all of the terms of the agreement?
I do.
Have you had enough time to think about them?
Yes.
Do you have any questions about them?
No, I do not.
Do you believe at this time that all of these provisions are in your daughter's best interest?
Absolutely.
And are you asking the court to make this agreement an order?
Yes.
Thank you. No further questions.
Thank you.
Thank you, Ms. Hills. Ms. Dinser, do you have any questions first off for Ms. Williams?
Yeah, I would just reiterate the same questions kind of that Ms. Hills asked. Mr. Ellison, did you...
I'm sorry, do you have any questions first off for Ms. Williams?
No, I do not.
Questions for Mr. Ellison, please.
Thank you. Mr. Williams, did you hear the agreement that we placed on the record?
Yes, ma'am.
And we came to that agreement through mediation with Josh Walker?
Yes, ma'am.
You participated in that?
Yes, ma'am.
and you believe that we reached the best agreement on everybody's account we could probably possibly get to today?
Yes, ma'am.
This settles everything?
Yes, ma'am.
Okay, and you're asking the judge to enter this order because you believe it's also in Sinai's best interest?
100%.
Okay. I have no further questions.
Thank you, Mr. Enzer. Ms. Hills, do you have any questions, Mr. Allison?
No, Your Honor. Thank you.
And Ms. Hills, you'll prepare the order?
I will.
Wonderful. First, the court would like to thank Mr. Walker for his fine assistance, and particularly Ms. Hills and Mr. Enzer for helping facilitate amicable resolution. The court would applaud you, Mr. Allison and Ms. Williams, for coming together and reaching your own agreement. You know what's best for your daughter, so continue to keep lines of communication open. Make life good for each other and your daughter. There'll be there's enough challenges in life. So, with pleasure, the court will adopt the agreement and enter the order upon presentment. So, again, good job. And that will conclude this hearing. You can all zoom out. Have the rest of the day.
Thank you, Your Honor.
Thank you.
You're welcome.
Thank you, Ms. Hills.